Good morning friends, this is KD sir from KD CVAM channel. I hope you all are doing well, right? Today once again we are going to continue with the Indian Evidence Act series. We are going to add another video to this series, right? Today's topic is judgments of Court of Justice when relevant. Okay, so let's start with the question. The question is, what is a judgment? Now, as per the section 2(9) of CPC defines a judgment as a decision which is given by the judge in a court regarding the rights, duties and liabilities of an individual, right? So this is called a judgment. Now, the judgment depends upon the facts of the case of a particular party and not by the references to the judgment of other cases. Every case has its own importance and own situations, right? So the judgment depends upon the facts of the case of a particular party and not by the references of the judgment of other cases. Types of judgment. There are two types of judgment. One is judgment in rem and another is judgment in personam. When a judgment is given on a particular subject matter, then it is applicable to the entire world, because it is going to be common for everyone. But judgment in personam, the name itself expresses personam, that is personal or individual. So when a judgment is given on a subject matter, it will remain between the parties only. It means the judgment is against an individual, only applicable to an individual. That is called judgment in personam. Now next is relevancy of judgment. How the judgments are relevant. Now, it means that every judgment is based upon the facts of each particular case. The judgment of each case is based upon the subject matter, and it is not necessary that the judgment of one case is interrelated with the another case, right? You cannot give a relevancy because it depends on the situation and the facts contained in the particular case, right? So, the judgment of Court of Justice when relevant. So today's our topic is this. Now this topic is discussed or explained in section 40 to 44 of the Indian Evidence Act. Now let's just go through the 41 all the section, then we will explain one by one. Section 40. The existing judgment will be relevant even in the second suit trial. Section 41. That certain judgments in probate, matrimonial, admiralty and insolvency jurisdiction are relevant. Section 42. The effect of judgment, order or decree is relevant other than those which are given in section 41. Section 43 says judgment, order or decree are irrelevant other than those mentioned in 40 to 42. Now, section 44 explains if the previous judgment may proved fraud, collusion or incompetency of a court, then such judgment does not have the effect of res judicata, right? So now let's go through one by one. The first one, the existing judgment will be relevant even in the second trial. Under the Indian Evidence Act 1872, section 40 defines that the existence of any judgment will be relevant even in a second trial. Here the rule of res judicata applies. It simply means that if any judgment which prevents the court from giving attention to such a suit or petition, then it will be a relevant fact. The question arises, what is res judicata? Many of you may have heard about the word res means subject matter and judicata means already decided. So once it is already decided, it becomes a relevant fact. So it says that the matter is already decided. It is defined under section 11 of CRPC. Next, let's take an example and case law of section 40. Now A and B are two parties. A sues B for the matters related to property, but the court dismissed the suit and then again A filed a suit against B. Now, so it was said that once the judgment is already given by a court over a particular subject matter, then that court does not have the jurisdiction and the formula of res judicata applies. Similarly, in the Criminal Procedure Code, bars a second trial of a person once tried convicted. Thus, the judgment by which he was convicted will be relevant to every case or proceedings in which he is charged with the same offense. So, केस लॉ अगर लें तो श्रीनिवास कृष्ण राव कांगो वर्सेस नारायण देवजी कांगो एंड अदर्स इन 1954. Section 41. Relevancy of certain judgment in probate, etc. in jurisdiction. The Indian Evidence Act 1872 says that a final judgment, order, decree or ruling of a court exercising probate, that is relating to will, matrimonial, that is marriage, divorce, admiralty, that is war claims, or insolvency jurisdiction is relevant. This is what the Indian Evidence Act 1872 says. Now this section consists of two parts. One, it is as we said judgment in rem, and another is judgment in personam, जो हम लोग ने already discuss कर दिया है, right? तो such judgment is conclusive proof if refers to a presumption of a particular set of facts which cannot be overruled or changed by additional evidence or argument. So if it is already decided or it becomes a relevant fact, then it becomes a conclusive proof, and such cannot be overruled or changed by additional evidence or argument. इसका एक केस लॉ है सैयद अस्कारी हादी अली वर्सेस स्टेट, दैट इज दिल्ली एडमिनिस्ट्रेशन. नाउ इस सेक्शन में लेट्स सी द काइंड्स ऑफ जुरिस्डिक्शन. एज वी नो दैट प्रोबेट, मैट्रिमोनियल, ये सब देखा तो वो उसका एक एक का डिटेल देख लेते हैं. प्रोबेट जुरिस्डिक्शन, it exercises the power of probate, surrogate or orphans court. It includes the establishment of wills, settlement of descendants estate, supervision of guardianship of infants. ये सब कवर होता है probate jurisdiction में. उसका एक केस लॉ है गौतम शांतिलाल शाह वर्सेस स्टेट ऑफ वेस्ट बंगाल 1996. वैसा है मैट्रिमोनियल jurisdiction. It exercises the power of marriage, divorce, authoro, the nullity suit. Now एग्जाम्पल केस लॉ है सांतिनी वर्सेस विजय वेंकटेश 2017. नेक्स्ट इज एडमिरालिटी जुरिस्डिक्शन. नाउ इट एक्सरसाइजेस द पावर ऑफ लॉ केसेस कंसर्निंग एडमिरालिटी, मतलब इट कंसर्न्स टू द शिप्स और द सी एंड अदर नेविगेबल वाटर्स. नाउ द एग्जाम्पल केस लॉ इज गोविंद राम वर्सेस लालचंद 2000. Now, insolvency jurisdiction, it exercises the power of the member state within the territory of which the center of the debtor's main interest is situated shall have jurisdiction to open insolvency proceeding. That what the state gets the power. That is the example case law है Krishna Swami Iyer and versus TV Swaminathan Iyer, that is 1924. Now, section 42. Relevancy and effect of judgments, orders, decrees other than those mentioned in section 41 of the Indian Evidence Act. The effect of judgment or order will be relevant except those which are mentioned in section 42. Right? The judgments are relevant if they are related to matters of public nature, but such judgment, order or proclamation is not conclusive proof of which they state. But just read out this statement that they are not conclusive proof of which they state. बराबर. Let's take an example. ये example बहुत सही रहेगा, right? X sues Y for the murder of his brother Z. X ने sue किया Y को for the murder of his brother Z. Now Y alleges the existence of public right of a licensed gun which he used for the protection of against Z. Now Z ने ऐसा कुछ किया होगा तो अपने राइट को बचाने के लिए उन्होंने Y ने एक लाइसेंस गन से उनको अपने प्रोटेक्शन के लिए मारा और उसमें शायद उनकी डेथ हो गई. तो that was the defendant, right? The exist of an order in favor of defendant. अब ये हमारा ऑर्डर रहा, ये जजमेंट रहा. अब ये जजमेंट रेलेवेंट बनता है कि नहीं देखिए. सिमिलरली इन अ सूट बाय बी अगेंस्ट ए फॉर द मर्डर ऑफ सी इन विच ए alleged the existence of the same right of way. Now is relevant, but it is relevant, but it is not conclusive proof that the right way of existence जरूरी नहीं है, right? Because the situation may be different. So everything has to be considered, that fact in issue and relevant fact. Now the case law example है Vishnudat Sharma versus Daya Sapra, that is 2009. Section 43. Judgment, order, etc. other than those mentioned in section 40 to 40 when relevant. This is what section 43 says. Now, judgment, order or decree are irrelevant other than those mentioned in 40, 41 and 42. Now, in this, the previous judgments are not relevant which concern the subsequent proceeding. Let us understand with an illustration. X prosecutes Y for stealing his horse from him. बराबर, आप समझ रहे हो? X prosecutes Y for stealing his horse from him. Now Y is convicted. Now after some time, X used to Z for the horse which Y had sold to Z before his conviction. Now as between X and Z के बीच में जो नया केस है उसमें जो पुराना जो जजमेंट है Y रिलेटेड Y अगेंस्ट, that cannot be relevant. तो each was against Y is irrelevant हो जाता है, right? This is what section 43 says. Now the case law is Emperor versus Bhagwan Das Tulsidas 1945. Now section 44. Fraud or collusion in obtaining judgment, right, or incompetency of the court may be proved, right? फ्रॉड करके या तो फिर कुछ कॉन्स्पिरेसी करके या तो कोर्ट हेल्पलेस मोड पे हो जाए, इनकॉम्पिटेंसी हो जाता है, तो दैट कैन बी प्रूव्ड, देन इट बिकम्स रेलेवेंट. इट सेज दैट इफ द प्रीवियस जजमेंट इज प्रूव्ड फ्रॉड, collusion or incompetency of the courts, then such judgment does not have the effect of res judicata, right? So there are at least two parties to a suit for proceeding. If any party may show a judgment, order or decree which is relevant under section 40, 41 or 42, the act only provides that the value of judgment may be ineffective if these three are present in that case. That is, one is incompetency of the court, second if there is a fraud, और इफ देयर इज ए कॉल्यूशन. तो अगर ये तीन अगर आपने प्रूव कर दिया तो ये जो रेस्ट जुडिकाटा जो है, मतलब 40, 41, 42 के जो जजमेंट्स है वो रेलेवेंट नहीं होते हैं. तो द केस लॉ का एग्जांपल है अशरफीलाल वर्सेस श्रीमती कोहली, दैट इज 1995. ओके, एंड सो फ्रेंड्स, द लास्ट स्लाइड कम्स कंक्लूजन. Judgment should totally be on the basis of the facts and the issues raised in the court. The court is also required to determine what principles of law should control the case. Now, the judges said that the system which is developed and applicable in one jurisdiction is not necessary to be applicable in the jurisdiction of other countries. This is what it says, right? So, students, I hope you got it, right? अगर आपको ये वीडियो पसंद आया तो प्लीज़ शेयर और सब्सक्राइब करो मेरे चैनल को, और इतना शेयर करो so that it reaches to all needy students and friends. Okay, keep watching my videos and please keep on commenting. Okay, thank you very much for watching. Let's meet in the next video. Bye, have a nice day.